Ms. Griffin. Excellent. All right, everyone. Just to remind you, 20 minutes aside. Mr. Baseman, you are the appellant in this case. How much time do you wish to reserve for rebuttal, sir?
I'll reserve the 5 minutes.
The 5 minutes. All right. If you could speak a little bit louder, I want to make sure I could hear you. Okay. Yes. Excellent. All right. You may proceed, sir.
So there are a couple issues in this case, but I plan on focusing on what I think is the primary issue, which is the alimony disposable military pay issue. Of course, if the court wants me to address any other issues, I'm happy to do so. For this issue, this has been extensively briefed, but I think that kind of belies that it's a relatively simple issue at the end of the day. This is a situation where the parties agreed to divide part of the husband's military pension using very, very specific language that mirrors statutory language. The trial judge determined that this was not really what the parties intended and effectively rewrote their agreement to serve an end decided by the trial judge.
Counsel, I need to make a upfront confession that I have some struggles understanding where you're coming from, I think, sort of like the judge did who presided over the case, because it seems to me that what happened is both parties entered into the marital settlement agreement on the assumption that the former wife was going to receive $1,095 out of the military pension. And then it turned out that the military pension was 100% disability and was not to be severed that way. So the judge basically substituted the money that everybody thought she was going to get for by giving an additional $1,095 in alimony. In other words, he just substituted one fund for the other and to make the former wife whole. Is that kind of what happened?
I think that is certainly what the judge was intending to do.
And on the financial affidavit signed by your client, doesn't it indicate that the $1,095 is an amount that he was fully expecting to pay and in fact did pay all summer long? Correct?
It is an amount that he believed was subject to equitable distribution.
So he was making the $1,095 payments from the time the marital settlement agreement was entered until this problem came up with the divisibility of the pension.
Not with the divisibility of the pension. The problem is there's nothing left to divide in the pension. This is identical to what the United States Supreme Court dealt with in the Howell case.
And this came as a big surprise to both parties, though, did it not?
I believe the record suggests that, so everyone was aware that the husband was 100% military disabled. So everybody should have been aware that at some point that number was going to change. I think it did probably come as a surprise that it was going to go down to zero. But again, I think this is identical to the situation faced by the US Supreme Court in Howell. And in that case, the US Supreme Court, the facts are that very much the same thing. The parties agreed to distribute the husband's retired pay.
Well, in fact, in the marital settlement agreement, they agreed that the wife was entitled to 36.92% of the military pay, correct?
In our case, correct.
Yes. And that number was computed to be, the after-tax number was $876, which if you gross it up per month, which if you gross it up, you get the $1,095. That's in the marital settlement agreement.
Clearly as an estimate of what was thought would be distributed, correct.
And then lo and behold, this letter shows up saying, oh, we can't take it out of the military fund because it's disability, because it's 100% disability.
Without meaning to completely parse the language, the letter says that, but the issue is not that they can't take the money out, but that under federal law, which the Supreme Court said preempts all state attempts to circumvent it, there is no money available to be distributed. And
there's no money to be distributed out of that fund. But as Judge Tharp pointed out, I think he said something facetiously like, I don't care if it comes from the tooth fairy. If they agreed that she's to be paid, then she has to get paid.
Correct. And he literally put in the order that it needs to be paid or can be paid from his 100% disability payments.
You're asking us to go ahead, Judge.
Yeah, if I may, Mr. Baseman, I guess the way I see this case, and correct me if I'm wrong, there's been an agreement by two people that you're going to agree to these terms. If after agreeing to that, and if one term of that agreement is really, people were under the impression that it would be there, but it's not. You don't have an agreement. And I think it's up to, we're dealing with a court of equity. We're dealing with a judge who's looking at the whole case to determine what has been the agreement by the parties. And in this case, as I see this matter, that there was agreement from your client to pay, I think Judge Black indicated, and it's true, and it says here, about $1,000, that she would get that amount. And part of the whole agreement, the whole scheme as to what she's going to be getting. And then come to discover that was not the case. The judge has every right to say, okay, if that was the agreement that you'll be paying for that, then we'll need to find a way how you could honor that agreement. It doesn't matter which pot you're taking it from. We've approved this agreement that she's going to get X number of dollars, including that amount. We need to make sure that that is actually what is being done. Why is that error?
That is exactly what happened in the Supreme Court case of Howell. They had a settlement agreement that said the wife would get 50% of the husband's military retirement. A portion of that had to be waived for his disability, and the wife wound up getting shorted what she expected. The trial judge in that case said the husband is going to indemnify the wife for what she expected. The Supreme Court of that state agreed, and the United States Supreme Court took that and said, no, Congress has made it very clear that the court cannot distribute disability payments.
And I think, Mr. Bass, I think as I see here, I think there's a focus so much on that pension or that disability payment, but you have to step back. What's the whole agreement? The whole agreement that she's going to get a certain amount of money as part of this whole equitable distribution, that she is going to get 1,000 gross in order to equalize both parties. And that part was going to come from that fund. And so you have to step back and to think, well, there's now that agreement is not really being honored. So let's go ahead and get back and make sure to put the parties back where to enforce that agreement and have your client, which he agreed to pay that $1,000. It doesn't matter from where, but he needs to be able to be held accountable for the agreement that he had signed off on.
And that was the law in the state of Florida until it was abrogated by Howell. Howell says it does not matter if the court is clearly trying to make up that money that was waived because of disability, that would be reversed. It does not matter what the form is. Howell is very specific. This is identical facts to what happened in Howell. And in Howell, the court says, I completely understand the fairness argument you're making, but what Howell says is everybody dealing with one of these military pensions needs to understand that Congress has made them contingent. Once part of it becomes disability, it cannot be given to the other side in any form whatsoever. They said, we don't care what the form is. In that case, it was called indemnification. Here it's being called alimony. And there's a dozen reasons the court couldn't have done alimony as well. And we can get to that if we need to, but I do think it's briefed.
Remind me, if you would, in the Supreme Court case, what was the posture of the case in the lower court? This is what was decided in a final judgment of dissolution, correct?
There was a final judgment of dissolution that included a provision to split the military retirement pay 50-50. The parties did that for a while. Then down the road, the husband had to waive some for disability. So the wife was getting the amount she expected, just like in our case. Then it went down, just like in our case. Now in that case, it went down by several $100s. Here it went down more, but that doesn't change the facts. So it was a post-judgment enforcement situation. Okay. And the order was to indemnify, to pay that difference. And the Supreme Court especially noted The fact that this is a dollar for dollar change makes it even more clear that this is making up for what was waived, which Congress has preempted. In our case, we also have an exact dollar for dollar. I can't stress enough that the Howell case is exactly on point with this case. And what Howell says is military retirement is a contingent asset. The courts, the parties, the attorneys need to understand that and need to account for that explicitly in their agreements or in the valuation of that asset.
Yes, but in our case, we have, in addition to the percentage that was agreed to, we actually have a dollar amount that was agreed to and a dollar amount that was used in computing the child support, all of which was agreed to at mediation by your client.
We have an estimate, and I believe the language is very clear that says the parties are estimating this amount will be. The parties, for example, expected there to be cost of living increases, things like that. They expected this number to change. The fact that they estimated is required by state law because you have to include the income in child support calculations. So had they not done that, that would have been erroneous and it would have deprived the child. So there was no choice but to include that estimation. The parties easily could have said something to the effect of, the wife has a need for alimony of X dollars. This is currently being met by this pension. If the pension goes away, the wife may be entitled to alimony. They did not do that. Again, this is exactly the facts of the Howell case. And the Supreme Court said, fair or not fair, Congress has made clear that the state's courts cannot do anything to fix this. This is something Congress needs to do. And in this case, it is crystal clear what happened here. And Your Honor expressed it exactly right. The judge thought she was being shortchanged and asked the husband, compelled the husband to indemnify, exactly what the United States Supreme Court said could not happen. And post 2017, no family law attorney, no family law party has an excuse to say they were not aware that this could be the result. It is wrong for Judge Tharp to have presumed that the parties didn't know this could have been the result. We do not know, for example, that this contingency wasn't factored into the equitable distribution award. Every attorney should know this is contingent. That's what the Supreme Court said. For Judge Tharp to come in and say, I think I know what the people intended here, and to completely rewrite the agreement violates Florida law on 4 or 5 different axes. You can't rewrite it.
We also have the testimony of the mediator as well as the party saying that nobody was planning for this eventuality, that this is not a part of this case.
But that's the job of a family law attorney. That's the job of any attorney writing a contract. This is a Supreme Court case from 2017. This was the law of the land. This was well known. You cannot presume. There was nothing ambiguous about this agreement. There's no reason to look at what the mediator said was the intent of the parties. I appreciate it's in the record, but we still start with the language of the agreement. The parties didn't even just say retired pay. They used a term of art. They used the term of art disposable military retired pay, which appears in the statute and is expressly defined as the person's retired pay minus anything they waive for veterans benefits and minus Chapter 61 benefits, which was what we're dealing with here. You have to presume the parties knowingly chose to use that language. Now,
doesn't that kind of undermine your client's testimony that he was shocked when his former wife advised him that that was the case? Doesn't that kind of give the impression that your client knew all along that was the agreement, that he was going to pay X amount of dollars so she could get as part of the whole entire package? Does it kind of undermine the thing about everybody was very crystal clear? Your client, his very words were that, in fact, when he testified, that he was surprised and he was shocked.
Sure, and I hope the court can appreciate I'm making the technical argument that you should be going off the 4 corners of this document. I think my client's statement that he was shocked that all of his money was being treated as disability, that's not inconsistent with the position that the parties could have at least expected this number to change. For Judge Tharp to say he will pay 1095 forever is simply not consistent with an understanding of what military disposable retirement pay means. That is not what that phrase means. And again, you know, I'm sure I'm running out of time, so I do want to quickly address.
You're about to go into your rebuttal. Feel free to go forward. You did reserve 5 minutes, so if you'd like to finish that thought.
I will quickly go through those 5 minutes. Okay. Even if the court decided this was not what the parties intended, the court did not have a right to rewrite this agreement. And the judge certainly did not have the right to make this a contempt enforceable, permanent, non-modifiable alimony award without considering need, without considering ability to pay. These things all violate Florida law.
How can they have rewritten the agreement when he put in his financial affidavit that that was an obligation that he was aware of and that was incorporated into the marital settlement agreement? I don't see where anything was rewritten. This is what they planned for.
I don't believe a financial affidavit should be treated as containing settlement terms, and I don't believe it was incorporated into the marital settlement agreement. I could be incorrect about that, but that is a discovery document. That doesn't have anything to do, respectfully, with how an agreement should be treated or enforced. I agree. We could start from the presumption that my client expected on day one that he would be paying 1095. And still, starting from that presumption, my argument still holds up. The court could not change this agreement to require indemnification, especially as it did by saying it should literally come from his disability payments. The Howell case is exactly on point. It simply says, we're sorry, this may be unfair, but Congress has said you can't do this. And the United States Supreme Court is saying you cannot do this. But even if you're correct, even if you're right about that, there is no reason to interpret that agreement to suggest that my client believed he would be paying 1095 forever. And to say that it should be treated as forever alimony, non-modifiable, permanent alimony, something that does not exist under Florida law, something that did not take into account need, ability to pay, anything like that, it's just incorrect for the 4 or 5 reasons that are laid out in the brief.
Actually, if you'd like to stop right now, you'll have 3 minutes for rebuttal, Mr. Baseman, okay?
Thank you.
Good. Thank you. And if I could trouble you to mute your microphone, Ms. Griffin, you could unmute and you have your 20 minutes, ma'am, whenever you're ready.
May it please the court. I'm Eileen Griffin and I represent Elizabeth Camrad. If the court looks at the child support guidelines that were attached to the marital settlement agreement and the final judgment incorporated the marital settlement agreement and the child support guidelines, there's a very specific use of different numbers that included the husband's salary as a process server, the husband's disability benefits from the VA. I was trial counsel. I knew in about a month before mediation that Mr. Camrad was 100% disabled by the VA. The VA is the Howell case. We knew at the time at mediation that Mr. Camrad would not receive from the VA any more than the $32.55, other than his maybe cost of living increases that they would give him, because that's 100% disabled pay from the VA, which he waived from his retirement. We took that out. We gave him his $32.55, 100% Howell money. That's the Howell money. There's a totally different a medical retirement that Mr. Camrad subsequently learned that the military provided for him that was different than the VA benefit. So when Mr. Baseman talks about that the Howell is the controlling law here, it is not. Howell dealt with a VA disability after the husband had retired. then he determined that there was a VA waiver and the wife was trying to recoup the VA waiver. In mediation, we already gave him 100% of his own VA waiver. So Howell does not apply here. And
Ms. Griffin, let me ask you a question, ma'am, because I realize this, reading this transcript, quite frankly, it was, there was a lot, the judge really interrupted a lot, and there was a lot of people talking over other people. So I guess my question is twofold. Yes, I understand what you're saying is that what was the agreement reached between the parties? And as I read your brief and I hear your argument that there was an agreement that the former husband would be paying a certain amount of money, which is $1,095, towards that, which is a percentage, whatever the percentage, 30 something percent. My question to you, ma'am, and in fact, let me ask you this question first. Your client testified she was under the impression she would be receiving net the amount of, was it $895? Is that roughly around that amount? Is that correct?
Yes, it's actually $876, and we put in our reply brief, or I'm sorry, my answer brief, that we consent to the $876.
Okay, so you do agree then, whatever the amount that was awarded by the court, the $1,095, it should have been instead, if we affirm that it should be the reduced amount of $876. I want to make sure to ask that first.
Yes, ma'am. We put that in our brief that was the amount after tax, and that was the amount that she contemplated. The lump sum alimony wouldn't have a tax effect, so it would be the $876. We concede to that and agree to a second amended final judgment that would address the $876. That was never an issue with us. I even told Judge Tharp at the hearing, and it's in the transcript, when I had provided Ms. Howe those proposed final judgments 3 days, because we had originally had set this on a UMC hearing on the 16th of September, and then the judge continued it and special set it for as long as we needed on the 19th, and which is when he signed the orders. I had given Ms. Howe my proposed orders, the two orders, on the 16th. And when he signed the orders, when we learned about the retired pay after the evidentiary hearing on the 19th, the VA disability is not taxable. This military retirement money is taxable. And at that time, I told Judge Tharp that I would agree that if he changed the amount on that order, because we had pre-printed not knowing about the taxability status, because we had never dealt with that before. And it was, we told him that it should be the $876, and he said no, and he signed it the way it was prepared.
Which then brings me to my next question. When I indicated I had twofold, help me if I can, because as I mentioned before, the transcript was really, it appeared that Judge Tharp really interrupted a lot. How do you respond to Mr. Basement that in the hearing itself, the court really made up its mind, knew right away what they're going to do, and did not allow at least Mr. Camrad to present his case and to basically provide him due process? How do you respond to that?
Your Honor, we started, as I said, on the 16th, and he was represented by counsel. I believe that if Mr. Camrad thought that he was not going to be able to get a fair hearing, he should have filed a motion to disqualify the judge, and he didn't do that. And truly, the comments that Mr. Basement puts in his brief about, I'm sorry, and I'm paraphrasing, I'll make the decision for you if you don't, that's exactly why we were there, because the judge had to make the decision for us, because we obviously wouldn't be there if we were able to have the decision made amongst, or reach an agreement. We couldn't. He said, no, I'm not going to pay you. And we had to go before Judge Tharp in order to get that enforced.
Now, I guess maybe to follow up with that, is that did Mr. Camrad was given an opportunity to fully present his case? Because if you look at the transcript, it appeared that at one point Judge Tharp basically left and said, okay, you need to resolve this. You need to resolve. Then came back. And when they were trying to do testimony, he kept interrupting and kept indicating as to what ultimately he ended up ruling. That's my question, is that as you know, we need to make sure everybody has had an opportunity to be heard and to present their cases fully. So my question, I guess, is very simple. Was he afforded that due process in this matter?
Your Honor, I believe he was, and there was nothing toward the end where when Karen Howe cross-examined or called her client, I called him as our witness first, and there at no time other than for the judge to say, try to resolve it, which happens often in family law trials. And then we go back, and if we don't reach an agreement, the judge will make a decision for us. But he never cut off Ms. Howe, the attorney, or Mr. Cameron and told them they could not present any more evidence. She had every opportunity to examine him, and there was nothing where in fact, Judge Tharp was getting ready to retire, and he had these additional days, and he said, we'll stay here as long as you need. I will give you every opportunity to present your case. And he told us we'd stay past 5 if we had to stay past 5. I had a court reporter there and told everybody, he told us we're gonna go as long as we need to, because we originally, when we went to the hearing, the UMC hearing on the 16th, he said, I'm gonna special set this for as long as you need, and this will be one of my last cases that I have. And I have that whole day, and we started in the afternoon, I believe, and he said, I'll let you go as long as you need. And I never heard anything and I don't think there's anything in the transcript where he, other than saying, try to figure it out, he never cut off the attorney's ability to present her case.
Thank you, ma'am.
And for all of the reasons that we've stated in our brief, I would ask that you affirm Judge Tharp in every way except for the amendment to the $876 per month as opposed to the $1,000 that he ordered.
Very good. Thank you, ma'am. And if I trouble you, Ms. Griffin, to please mute your microphone. And Mr. Baseman, you actually have 3 minutes for rebuttal, sir. All right?
I will try to go quickly. Howell is not only about this limited form of VA benefit, it is about what the court can do to distribute money that is not considered part of the military retired pay. It just happened to deal with one of the deductions for military retired pay. The Chapter 61 benefits are just another section, a different deduction from it. And that's why I provided the court in my reply brief the Guerrero case out of Alaska, their Supreme Court, which dealt with exactly this type of benefit and reached the same conclusion. It predated Howell, but it used the same logic. It also followed the Mansell case that the Supreme Court did. I do want to address, again, I understand the fairness arguments. I understand all of that. Had Ms. Griffin filed a motion for relief from judgment, arguing no meeting of the minds or something of that nature, mistake, I still think it would have been incorrect. I still think it would have violated Howell. But moving past that, the court potentially could have set aside their settlement agreement and said, either you guys settle again knowing this, or we're going to trial. For the court to cross out one term and change it to another term, again, presumes that none of the terms of that settlement agreement were contingent on each other, relied on one another, or were thought of as part of an overall compromise. Florida law is very clear. A court cannot just change terms of an agreement. That is what happened here. And again, it probably is correct that on day one, my client expected that he would be paying $1095 or the estimated $876, whichever it is, to his wife. That number was always subject to modification, always subject to change. There is no reason at all to believe that either party expected or reasonably expected that that number would stay the same forever. For the judge to make that a non-modifiable permanent award is not even close to the term that the parties agreed on. It defies common sense to think that that is what my client expected to do. And I do want to address again, the agreement merely says, it's very specific that the parties are going to divide 37% of the disposable military retirement pay. Again, a term of art in the statute. And then it just says it's estimated that for the time being, that amount is going to be $876. It just says it's estimated. That is not a term of the agreement. It does not say this agreement is contingent on the wife receiving this amount or that this is a critical term of the agreement. The term is 37% of the military retired pay. Again, I can only stress this is exactly what the court saw in Howell. It's exactly what the Arizona...
The 870, counsel, the 876, the $876 comes after taking a 20% tax effect off of the $1,095 that appears on your client's financial affidavit. I mean, it's not a number pulled out of the air.
If I implied that, that was not what I was trying to imply. What I'm trying to say is that was not a term of the agreement. It did not say this agreement is contingent on the fact that she's going to receive this. It was estimated for the time being because there was going to be a delay in receiving the payments. Again, I do want to say, I know my time is up. The Howell case is precisely on point. I ask the court to please look at it. The arguments that you're making are exactly what the Arizona Supreme Court said, and the U.S. Supreme Court said, we're sorry, you cannot do this in a family law case.
Very good. Thank you, Mr. Baseman. Thank you, Mr. Griffith. And if we could have you now sign off. Thank you both. Thank you. Great. Excellent. All